Welcome, everyone, to our panel discussion, The Future of Religious Liberty, and more importantly, the inaugural event of the first law school clinic on religious liberty. Now, I'm not a judge, but if I was and I had my gavel handy, I would have been banging it to get everyone going. But we are here, and we have started. And let me just say before I have an opportunity to introduce the panel that it is a true pleasure to be here and a true honor to be present for this occasion. Just by way of personal anecdote, just to get a sense of why what we're doing is so important here. My first job was built on a dare. Okay, I had a thriving baseball card business growing up, buying and selling baseball cards. I didn't ever got a summer job because I was making more money buying and selling baseball cards to my little friends. When I was about 15, a work colleague of my father said, "You will never ever get a job at McDonald's because of your turban." I said, "No, you're wrong. I think I can get a job at McDonald's." So based on a dare, I gave up my lucrative baseball card business and worked for McDonald's. Lo and behold, 2 weeks later, I was indeed fired. Now, it wasn't for the reason, I just saw a head go up. It wasn't for the reason you might think or that we feared. What happened, in fact, was during a lull in the afternoon shift, I had a Big Mac sauce fight with one of my coworkers and was fired. That said, the concern that an elder in my community had with regard to the intersection of the expression of their faith and the public square are very real issues. Very real issues here in the United States today that still exist. And having this law school in a wonderful marriage with the Becket Fund, the gold standard meets a gold standard, and it has a baby called the Religious Liberty Clinic with Jim over there as a proud papa and mama, is quite a marriage and bodes well. So with that, I welcome you here. I'm very honored to be here, and let me introduce the panel, and then we'll hand it off to Judge Beyer. Just immediately to my left is a name everyone knows. It's Professor McConnell. His bio is there for you, so I'm not gonna read from it. All I'll say is that I am awestruck. As a law student, a long time ago, I did read his articles in my third-year clinic, which was on religious liberty. It wasn't a legal clinic; it was just a small course that we had to take to graduate and write a paper. At the time, the Religious Freedom Restoration Act was still applied to more than the federal government, and I wrote my paper about that and read some of his comments on it. So it's really a pleasure to be sitting now on the panel of someone I read when I was in law school. To my second to my left is Judge Beyer. Again, won't read his bio, but I'll just say that it's very inspirational to know that he's in the position he is in now. It speaks to the strength of our country that we can incorporate and elevate Americans of any background and make them a part of the decision makers in our society. Two to my left is Hannah Smith, and I'll say this. I read her bio, and let me say this about this clinic and the work with religious liberty. Now, I'm a Sikh who happens to also be politically a progressive. So as I've read up on Hannah, I don't always agree with every position that she might have taken in the public. Let me say this, though. In this work, there are many issues, and it's not like this in the rest of Washington, that progressives and conservatives agree on. there are many issues. And the beauty of the marriage, for example, between my organization, the Sikh Coalition, and the Becket Fund is we've found those intersections and we've worked hard together. You know, having Hannah and being able to work with someone like Hannah as part of her work with the Becket Fund, I think speaks to the strength of people being able to find ways that they agree, taking religious liberty and lifting all of our boats by fighting for one particular community, in this case, Beckett's work with the Sikh community. Forward to my left is Rabbi Meir Soloveichik. You know, I'll say this. I had a chance to read his invocation that he gave at the Republican National Convention, and if you haven't had a chance, it's not in the bio, but it's worth looking up. It speaks to values of liberty that impact us all, and it's quite inspirational. And then finally, all I'll say, you know, all the way at the end is again the proud papa and the proud mama. Our hopes are with him and with his leadership of this clinic. It bodes well for religious liberty that this is the person who's leading this charge, and I'm so happy he's here. So with that, I will hand it off to Judge Beyer.
Thank you very much, Amardeep. I'm very happy and honored to be here to inaugurate the Religious Liberty Clinic with this distinguished panel of knowledgeable speakers. And a clinic in this area, I think, is needed to clarify through litigation at least one area of religious questions, the display of religious subjects in the public area, the public square. Only a year ago, Justice Thomas highlighted the apparently confused state of Supreme Court jurisprudence in this area in his dissent from denial of certiorari in Utah Highway Patrol Association versus American Atheists. He wanted the court to grant certiorari to clear up as far as the crosses placed along Utah highways to commemorate fallen troopers, whether the Lemon endorsement test or the Van Orden context test should apply to religious displays in public areas. He said, since the inception of the endorsement test, we have learned that a creche, that is a nativity scene, displayed on government property violates the Establishment Clause, except when it doesn't. He was referring to the creche unconstitutionally placed inside the courthouse that was an issue in the ACLU versus Allegheny County case, and the creche constitutionally placed in the Pawtucket, Rhode Island Park in Lynch versus Donnelly. He went on to say, a display of the 10 Commandments on government property also violates the Establishment Clause, except when it doesn't. The identical text was hung inside a Kentucky courthouse in McCreary that was unconstitutional, whilst when graven on a granite slab and placed in a public park, it was constitutional in Van Orden. Finally, he said, a cross displayed on government property violates the Establishment Clause as the 10th Circuit held here in Utah, except when it doesn't. The crosses on county seals in county buildings in Friedman and Harris were unconstitutional, while a cross sculpture outside a city sport complex and mural of crosses on an elementary school wall was constitutional in Weinbaum versus Las Cruces. There was hope, at least on the cross issue, that it might be cleared up in Salazar versus Buono, which involved an 8-foot-tall cross on a rock in the middle of a Mojave Desert federal park until the land was sold to a veterans organization. The plurality said a cross by the side of a public highway marking, for instance, the place where a state trooper perished need not be taken as a statement of governmental support for sectarian beliefs. But the case was remanded to the district court for further proceedings and then settled. I commiserate with Justice Thomas that the Utah highway case was not granted certiorari, but for a totally different reason. Unlike Justice Thomas, I was able to see quite clearly the reason why apparently conflicting decisions were reached in the Kresh, Ten Commandment, and Cross cases. And I'm surprised the bright line drawn in those cases has not been commented upon by such leading lights as the Stanford Law Review. It is all quite simple if you just pay attention to the facts. Creches. In Allegheny, the prohibited creche was in the county courthouse. In Lynch, the permitted creche was in the park. Ten Commandments. In McCreary, the prohibited parchment text was in the county courthouse. In Van Orden, the granite text was in the park. Crosses. In Friedman and Harris, the seals were inside county courthouses, while the crosses in Weinbaum were in the outside air. This led to the bright line of authority with which lawyers could confidently advise clients and judges could decide cases. If the religious symbol could be rained on, it was constitutional. If it was under a roof, it was unconstitutional. Thank goodness the rule is not completely abandoned by the court for a denial of certiorari in Bono. We are told is not a decision of the merits and does not create precedent. So I'm here to urge the Religious Liberty Clinic to litigate to a clear determination. Does the rain versus roof rule still stand? I will now call upon each of the panel members in the order in which they were introduced. They will speak for approximately 10 minutes. Then I have some questions to ask them as moderator, and then we'll open up if we have time, to the rest of the people here to ask questions. So, Professor Michael McConnell.
Thank you, Judge Bea. And one of the most revealing and inspirational moments around the founding occurred in Philadelphia at the time in celebration of the ratification of the Constitution. So the city decided to hold a great public festival in honor of the ratification. And there was, of course, food involved, and so they had tables of food to ease the occasion and to bring it in. And among the tables of food at this public celebration was a table of food appropriate for the Jewish residents of Philadelphia, a table of kosher food. And I think that this event is emblematic of something that was different in the United States from any other previous nation. We were not the first place to have some kind of religious freedom, but I think this public celebration in Philadelphia shows what kind of religious freedom was going to be enjoyed in the United States. First of all, it's one based upon principles of inclusion, right? That it's welcoming. It is not mere toleration, right? It isn't that we have some officially dominant group. Although, of course, demographically, there was a dominant group, but not officially and not publicly. Instead, the others are not just tolerated but welcome, are fully part of the event, and secondly, that this is in public, right? There have been regimes in which the freedom of religion is understood to be a completely private matter. I think, for example, of a statement by the famous Jewish philosopher and poet Moses Mendelssohn in connection with France, where he said, "Be a citizen in the streets and a Jew at home." Right? Be a citizen in the streets but a Jew at home. But that's not the message that you get from this table of kosher food at Philadelphia. It's okay to be a Jew in public too, that it's not a matter of repressing religious expression to the purely private. And this this spirit of freedom, I think, is perhaps unique to the United States in the world. But even here, even with that kind of a founding, and even with the words of the First Amendment to express that kind of a founding, things have not always been so happy, and especially not always so happy for religious minorities in America. At the founding also, the first, he was not yet then Chief Justice, but the person who was going to become the first Chief Justice of the United States Supreme Court fought at the New York New York Convention for the New York Constitution to exclude Roman Catholics from citizenship in America. It's a big fight. He was defeated ultimately, but that was an attempt. And it wasn't long thereafter and that was a time when Catholics constituted less than 1% of the population of the United States and were no threat at all. As larger numbers of Roman Catholics came to these shores, especially from Ireland, but also from other places in Europe, the conflict between Catholics and Protestants became much more severe. In one famous state Supreme Court decision, a 12-year-old public school boy named Thomas Wall was beaten with a rattan cane because he refused to recite the words of the Lord's Prayer from the Protestant version of the King James Bible. When the people of the city council or school board, the government of Philadelphia voted to allow Roman Catholic students in the public schools to use their own Douay version of the Bible, riots broke out in Philadelphia, and a Catholic church was burned down. In the wake of the Civil War, the President of the United States, Ulysses Grant, made a speech to an important political event in which he said that now that the Civil War is over, the great divide is going to be between enlightenment and superstition on the one side. Superstition on the one side and enlightenment on the other, and by that he meant the divide between Roman Catholics and Protestants. And then as the 19th century wore on, the Mormons became one of the major targets. The LDS Church was on the verge of military attack and physical extermination prior to the Civil War. The largest encampment of American military in the entire country was in Salt Lake City, Utah, preparing to attack Mormons in Utah. And had it not been that the Civil War broke out and those troops were wanted elsewhere, the Mormon Wars would have started. And then as the century wore on, Congress voted to disband the church and seize all of its property. One of, I think, the most ironically named cases in the history of the United States Supreme Court toward the end of the 19th century is a case called the Late Church of Jesus Christ of Latter-day Saints versus the United States, upholding the act of Congress which approved the dissolution of the church and the seizure of its property. Other groups have had their difficulties as well. The Jehovah's Witnesses were the principal victims in the middle part of the 20th century. I believe it's something like 30 cases involving conflicts between the Jehovah's Witnesses and local governments got up to the United States Supreme Court during this time. The witnesses don't win all of them, but they win almost all of them, except that they did lose the one in which they challenged being required to pledge allegiance in school. By the way, this is prior to the addition of the words "under God," so it's not. This had nothing to do with that. It had to do with pledging allegiance in general. And when the Supreme Court upheld that toward the beginning of World War II, acts of physical violence and assaults on Jehovah's Witnesses broke out all over the country. And so, we have principles that we start with and principles that we stand for, but they are principles that continually need to be fought for. Just because they're on the books does not mean that they're going to be enforced. It requires a vigilance, requires effort, requires lawyers, right? And that's what we're here about. And every era has its own issues. So we don't expect the same problems today that are going to be, but every era throws up its own religious liberty conflicts. And I just want to conclude by kind of guessing what are the main sources of conflict that we will now see. And it seems to me that there are two. One of them is spurred on by the very increasing diversity of religious practice in the United States, which in one hand, I think that tends to support and strengthen the underlying political support for religious freedom, but it also creates problems for a bureaucracy. It becomes so complicated to deal with problems, and so I think a lot of the cases that we see and some of the cases that the clinic has lined up to litigate are not really bigotry cases. What they are bureaucratic indifference cases. It's where we just can't bother. We can't take the trouble to deal with these pesky people who want to do odd things that we don't quite understand and don't fully sympathize with. It's easier just to say one size fits all, obey the rules, everything the same rules apply to everybody. So I think bureaucratic inconvenience is a major source of problems in our era. And then this is maybe a little bit more skeptical and maybe a little bit darker, but I do also think that sociologically in this country that we are developing a somewhat different religious divide. For many decades, most of the history of the country, the largest religious divide was the Protestant-Catholic divide. And a lot of religious liberty issues swirled around that problem. I think sociologists would support that increasingly the divide in America is not between Protestant and Catholic, indeed not between one religious group and another, but rather between religiously committed and especially seriously religious committed citizens and those who are not. Some of those being actual militant atheists, some being simply indifferent, but but increasingly I think we're going to be seeing clashes between those people who have these deep commitments to a variety of religious traditions, all different, but having something in common, namely this kind of allegiance versus for those who don't understand it, think it's pre-modern, think it's superstitious, think it's reactionary, and do not approve. And so my guess is that the clinic, if this clinic is going to be addressing the religious freedom issues of our day, I think we'll probably see some of each of those. But this I know for sure, which is that it's needed, and it's not needed because the United States is uniquely persecuting or anything. It's not. We are the free. I believe that we are the freest and the most a welcoming country in the world. I think there's a lot of that spirit of the table at Philadelphia still among us, but not always, and we still need to fight and to think and to litigate and to protect. Thank you.
Thank you, Professor McConnell. Now we're going to hear from Rabbi Meir Soloveichik from Yeshiva University in New York.
Well, thank you, Judge, and it's an honor to join such distinguished co-panelists here, and a real joy to join Stanford and the Becket Fund in celebrating this extraordinary occasion. I want to build on Professor McConnell's wonderful words by analyzing from an American Jewish perspective the uniqueness of America. And here it seems worthy to begin by citing the great New York theologian, Yogi Berra, who was once told that the mayor of Dublin, Ireland was Jewish. And the great Yogi ruminated and said, "The mayor of Dublin, Ireland is Jewish, only in America." So my hope is to reflect on really a certain only in America story that allows us to understand what we are celebrating today. It was in July of 1776 that a Jew, a colonial Jew who originally made his home in New York and then in Philadelphia, a Jew by the name of Jonas Phillips, sent a letter to an acquaintance in Holland, apprising his friend of the extraordinary events that were occurring in Philadelphia. Phillips enclosed a copy of the new Declaration of Independence. His letter, strangely enough, is now in the London Public Records Office. You see, the ship bearing this letter to Holland was boarded by the British, who could not make heads or tails of Phillips's communication, but for the copy of the Declaration enclosed within. Seeing the Declaration that was enclosed, the British ascribed the illegibility of the enclosing letter to it being a patriot-coded communication. And so they brought it back to England for further study. Comically, Phillips's letter was innocuous, and the sole reason that the British were unable to read it was because it was written in Yiddish. Phillips's letter may have been insignificant, but Jonas Phillips himself did indeed embody the Declaration's principles, as it can be said that he became the first advocate for religious liberty in this new nation. When the Constitutional Convention met in 1787, Phillips wrote George Washington a letter complaining that all public office holders in Pennsylvania were required to affirm that the New Testament was given by divine inspiration. This, Phillips wrote, quote, "is absolutely against the religious principle of a Jew, and it is against his conscience to take any such oath," end quote. Phillips then asked that the convention create a country in which, in his words, all religious societies are on an equal footing, meaning where all faiths were able to engage in public service, be part of the legislature, etc., while remaining true to their respective beliefs. Phillips then added that, quote, he's writing to Washington, "The Jews have been true and faithful Whigs, and during the late contest with England they have been foremost in aiding and assisting the states with their lives and fortunes. They have supported the cause, have bravely fought and bled for liberty which they cannot enjoy," end quote. So Phillips, in other words, is audaciously, consider the chutzpah that he has here. There are 3,000 Jews in North America at this point, and he is writing to George Washington, the most famous man in America, and telling him that the Jews were not equally able to serve society without violating their conscience, and that therefore they were not truly free. The Constitutional Convention, as we know, ended up creating a constitution that banned any religious tests for federal office. Several years later, Jonas Phillips was called to testify in a Philadelphia court on a Saturday, as courts were then in session 6 days a week. Phillips refused, explaining that Saturday was his Sabbath, and he believed, of course, that true equality demanded that he be allowed to obey the dictates of his conscience, the general law notwithstanding. Professor McConnell has called this, quote, "the first recorded case raising free exercise issues following the adoption of the First Amendment, end quote. Phillips's arguments unfortunately fell on deaf ears, and he was fined £10 for refusing to violate his religion. But the story does not end there. If you've ever toured Monticello, Thomas Jefferson's estate, you may have missed a Jewish grave on the grounds, whose headstone, inscribed with Hebrew rather than Christian dating, reads, quote, Rebecca Phillips Levy died 7th of Iyar, that's a Jewish month, 5591, that's Jewish year. This is the daughter of Jonas Phillips, and she is buried closer to Jefferson's dream home than Jefferson himself. Phillips's grandson, you see, was the naval war hero Uriah Phillips Levy, who ended up buying Jefferson's estate and saving it from ruin. Uriah buried his mother Rebecca there, and when Uriah died, he left the estate to the American people. It's fitting and perhaps providential that the man who lived his life fighting for religious equality, Jonas Phillips, fathered a family that saved the home of the man who authored the Declaration that all men are created equal, a home this family bequeathed to America. The story of the Phillips family and the Jewish grave at Monticello provides us, I think, with a fitting metaphor with which to approach religious liberty, to wit, of seeing America as Monticello, as a home that different faiths can build and preserve together. Britain's chief rabbi, Jonathan Sacks, reports that he used to meet with Tony Blair when he was prime minister to discuss whatever biblical passage Blair happened to be reading. They didn't say publicly that he was reading the Bible, because in Britain you don't say that, as Blair's spokesman famously said in Britain, quote, "We don't do God," end quote. So this was a private thing. It was just him and the prime minister, and he would ask him whatever religious questions were on his mind. So once Blair said to Rabbi Sacks, "Jonathan, I've reached the boring part of the Bible." So Rabbi Sacks says, "Which boring part of the Bible have you reached, Prime Minister?" So Blair says, "The tabernacle does go on a bit, doesn't it?" Indeed it does. The book of Exodus describes in intricate detail 600 verses, the different Israelite tribes, each contributing whatever they had, both material and creative skills, to creating a tabernacle. This was the origin of the synagogue, in which to serve God. The creation, 600 verses. The creation of the universe in Genesis by God, 34 verses. Now, the simple answer, as Rabbi Sacks pointed out, of course, is that synagogues are built by committee, so it takes much longer. But really, why the apparently excessive elaboration as to the tabernacle? The lesson, Rabbi Sacks said, is not only theological, it is political, as the tale of the tabernacle appears not in Leviticus, where we might expect it, the book of the sacrificial rites, but rather in Exodus, in which Israel emerges as a covenant nation. As Rabbi Sacks says, to turn a group of individuals or diverse tribes into a nation, they must build something together. It was built out of difference, each a distinctive contribution. Some brought metals, others jewels, others their skills and time. So, in other words, unlike the creation of the world brought into existence by the Almighty alone, the tabernacle illustrates that a polity requires individual efforts by many. As Rabbi Sacks says, how do you turn a group of people into a nation? God's answer is dazzling in its simplicity. A nation is built by building. You get them voluntarily to create something together. The tabernacle represents, in Rabbi Sacks' words, integration without assimilation. Because we are not the same, we each have something unique to contribute, something only we can give, end quote. Society for the Bible is, in Rabbi Sacks' words, the home we build together. And the tabernacle story is one that teaches us that we need not deny our differences to covenant as one nation. So it's fitting, I think, that Jonas Phillips' family saved Jefferson's home and gave that home to America, an embodiment of an America as the home we build together. And the unabashedly Jewish headstone in Monticello represents the integration without assimilation for which Jonas Phillips fought. And if we are willing to exempt faiths from laws that violate their conscience, it is because the founders believed that only in allowing religious difference can Jeffersonian equality be achieved. That people of faith find themselves, only then will people of faith find themselves, in Jonas Phillips' words, on an equal footing. Professor McConnell has noted that we apply the Declaration's ideals of equality in America to religion differently than we do to race. As he put it, human equality means that differences based on race are irrelevant and must be overcome. The ideal of free exercise of religion, by contrast, is that people of different religious convictions are different and that those differences are precious and must not be disturbed." End quote. The Phillips family plot in the home of the author of both the Declaration and Virginia's Statute on Religious Freedom is an eternal testament of the ability of American faiths to preserve our differences while being welcomed for our unique contribution that we can make to this country. And it is an eternal reminder to Jews in America to make Jonas Phillips's fight our own. We need reminding of this once more. In an age when many seem to believe that religious difference or even faith itself is not worth protecting. In this past year, we have seen an administration put forward the argument to an incredulous Supreme Court that religious communities do not have the right to choose their own ministers. 2 centuries after Jonas Phillips was fined for refusing to obey a legal obligation that violated his religious beliefs, Catholic businesses, charities, and hospitals are threatened with similar fines for refusing to obey a law, a mandate that violates their religious beliefs. And if Americans of faith cannot serve society while remaining true to their beliefs, then Jonas Phillips would say that they are not truly free. Phillips' story is as important today as it ever was, and that is why I feel so privileged to be here as this clinic is being inaugurated. On July 4th, 1826, 50 years to the day that the Declaration was signed, John Adams died in Quincy, Massachusetts. His famous last words were, "Thomas Jefferson survives." Unbeknownst to Adams, Jefferson had passed away that very day in Monticello several hours before. But Adams spoke the truth. Thomas Jefferson did survive because the ideas he articulated endured. 200 years ago, Jonas Phillips fought for the realization of the Declaration's principles. Today, this clinic carries on that fight to make America the home we can truly build together, to fulfill the founder's vision. It is my prayer and my hope that through the success of your efforts here at the Religious Liberty Clinic at Stanford, we will all be able to echo Adams and say, Thomas Jefferson survives, Monticello's legacy survives, and Jonas Phillips lives as well. Thank you for having me.
Thank you very much, Rabbi Soloveichik. Our next speaker is Hannah Smith, who's a senior lawyer for the Becket Fund for Religious Liberty, with particular interest in the religious freedom of groups, that is, the debate over the HHS mandate for employer contraceptive coverage or the ministerial exception to employment discrimination laws. Hannah?
Thank you very much. It's an honor to be here with you today. I just want to recognize some of my colleagues who are here with me from the Becket Fund. President Bill Muma, our Executive Director, Christina Arriaga, our 2 Deputy General Counsels, Eric Rasbach and Luke Goodrich, as well as our Director of Development, Montserrat Alvarado. They have been instrumental in helping bring to pass this day and the launch of this clinic, and I just want to recognize them and for their great efforts. So on behalf of the Becket Fund, I just would like to commend Stanford for its leadership in creating the first religious liberty clinic in the nation. I think it will unite people of goodwill who seek to protect the basic human right and civil liberty of religious freedom. I also want to congratulate Jim and his team for their work in what promises to be an essential and indeed successful endeavor. So I was asked today to provide some background on the Becket Fund for Religious Liberty, who we are, and some of the pressing religious liberty issues of the day, as well as some of the litigation efforts that we're currently involved in, and all of that in 10 minutes. So I'm going to do my best. First of all, the Becket Fund is a nonprofit, nonpartisan, public interest law firm that's based in Washington, D.C. It is the only such organization in America that protects the religious freedom of people of all faiths. We were founded in 1994 by a devout Catholic, Kevin Seamus Hassan, and since then the Becket Fund has defended the religious freedom for people of all faiths, we like to say from A to Z, including the Amish, Buddhists, Christians, Hindus, Jews, Muslims, Native Americans, Sikhs, and Zoroastrians. We believe sincerely that religious freedom is a God-given right for all people, and that in a pluralistic society with many differing views on religion, we believe that protecting this basic civil right of religious expression is an essential part of our constitutional order in our increasingly diverse modern society. So the Becket Fund works in the courts of law. We choose our cases carefully to set precedent in important issues in jurisdictions around the country. We work in the court of public opinion by appearing in national and local news media outlets to persuade our fellow citizens, and also in the academy through publications and now through this clinic. We do work both domestically and abroad, but today I'm going to speak primarily about our domestic litigation initiatives. We have recently identified at the Becket Fund several patterns as the most pressing issues or national concerns to religious freedom today. And I just want to talk to you about some of those briefly today in the time that I have with you. The first has already been alluded to previously by Meir. The first area of concern is the effort by some to restrict the freedom of churches and faith-based associations to organize and choose their own leaders based on religious criteria free from government intrusion. Some of you may recall a rather significant victory last year at the Supreme Court called Hosanna Tabor Evangelical Lutheran Church and School. We have in the audience today the attorney, Professor Doug Laycock, who argued that case before the Supreme Court. So the background of that case is that for 40 years, the federal courts of appeals and many state Supreme Courts recognized something called the ministerial exception, a constitutionally based rule exempting certain religiously based employment decisions from the reach of certain employment laws. And in the Hosanna Tabor case, the Solicitor General's office argued before the Supreme Court that the ministerial exception should not exist. This was a direct head-on attack challenging the very existence of religious autonomy in the hiring and firing of ministerial employees. Alternatively, the Solicitor General's office argued that even if there were a ministerial exception, it should be limited to only those employees who performed exclusively religious functions. Now, last January, a unanimous opinion of the Supreme Court rejected both of those arguments out of hand, calling them extreme, remarkable, and untenable. And I just want to underscore how rare it is to get a unanimous opinion at the Supreme Court, especially in a case like this one. And the Supreme Court held instead that there is a ministerial exception that protects broadly the right of churches to choose their leaders free from judicial intervention. So you may ask, well, if Hosanna Tabor came out the right way for religious freedom, then why is there still a concern? Well, the answer is found in this particular category in another Supreme Court decision from 2010 known as Christian Legal Society v. Martinez. And there, administrators at state-funded and even private universities around the country are using that decision in CLS to create and enforce policies which would require religious student organizations to allow students who don't adhere to their faith to be leaders in their student groups. And these policies are unfortunately having the effect of driving religious student groups off campus and perhaps into extinction. So that's the first trend. The second area of concern to religious freedom is that of discrimination against churches and synagogues and mosques that want to exercise rights to use privately owned property or to enjoy access to public property on equal terms with secular groups. Recently, the Becket Fund represented the Islamic Center of Murfreesboro in Tennessee when local community groups sought to prevent the building of a mosque in that community. Although the County Planning Commission approved the new mosque at a regular commission meeting, after having provided regular public notice for such a meeting, a state court judge held that the notice for the commission meeting was not sufficient. Because of the tremendous public interest surrounding the mosque, the judge decided that the county commission approval process should have been subjected to a heightened legal standard. We filed a federal lawsuit along with the Department of Justice requesting that the court require the local government to grant the building permit, arguing that subjecting the mosque to a different legal standard than a Christian church violates the Constitution. The federal judge granted the temporary restraining order, which meant that the mosque was able to complete the finishing touches on its building in time to celebrate Ramadan. The third area of concern touches on conscience rights. And indeed, it's the religious freedom of individuals to be free from government regulations that require them to dispense drugs that violate their religious convictions. And here I'd like to talk to you about our case called Stormins v. Soloveichik. The Becket Fund actually represents several religious pharmacists in lawsuits in Illinois and in Washington state, challenging state regulations that require these pharmacists to stock and dispense what they believe to be abortion-inducing drugs, even when doing so violates their religious convictions. In Illinois, the regulations have now been definitively struck down in state court. In Washington state, that's the Stormins v. Soloveichik case that I referred to. My colleague Luke Goodrich, who is here today with us, continues to represent our clients on appeal before the Ninth Circuit after the district court found the regulations unconstitutional based on the arguments that we made in court. The fourth area of concern is protecting the religious liberty of incarcerated persons. The Becket Fund currently represents several Jewish inmates in separate lawsuits challenging the Department of Corrections in Texas and in Florida to ensure that our clients are provided kosher food during their incarceration. Our lawsuits are primarily based on the Religious Land Use and Institutionalized Persons Act, which prevents the government from placing a substantial burden on religious exercise of a prisoner, even if the burden results from a rule of general applicability. And those cases are ongoing. The fifth area of concern actually relates back to Judge Bea's comments, and that is the effort by some to expunge all evidence of religion from public life. And this is manifested in lawsuits, for example, insisting that courts strip under God from the Pledge of Allegiance or otherwise remove religious symbols from the public square, which Judge Bea already referenced earlier in his remarks. The Becket Fund has been defending the words under God in the Pledge of Allegiance in lawsuits from California to Massachusetts. In the California case, we successfully argued before the Ninth Circuit that the phrase under God affirms a foundational premise in the American political tradition of law and rights, namely that human rights are not bestowed by the state, but are rather derived from a source beyond the state's discretion. Thus, the words under God do not unconstitutionally advance religion, but rather reflect the deeply rooted philosophical, political philosophy of the Founding Fathers, who believed that these rights derive from a source greater than a government made of men. The Ninth Circuit agreed and upheld the pledge based on those arguments. Finally, I just want to touch on the last two areas of concern. The next area of concern is state constitutional provisions that are rooted in discrimination against faith communities known as Blaine Amendments. The U.S. Supreme Court has recognized in one of its cases that the passage of state Blaine Amendments several generations ago was rooted in anti-Catholic bigotry. Today, Blaine Amendments are used as a weapon, for example, to block school choice programs that would enable students attending religious and other private schools to benefit from public funds on an equal basis with public school students. The Becket Fund currently represents several disabled children and their families in lawsuits brought by the school districts against these students. The school districts are seeking to prevent these disabled students from using state scholarship funds in private schools that are tailored to the needs of these disabled children, merely because these schools may be religiously affiliated. And they are using the state's Blaine Amendment for these ends. And finally, I'll just briefly touch on the last category, which is these government mandates that force religious individuals and communities of faith to choose between violating the law or violating their religious convictions by paying for drugs and services that violate their faith. And this is something that Meir had alluded to earlier. The HHS mandate cases, there are currently over 40 of them going on around the country. The Becket Fund filed the first of these cases last fall, and we are litigating on behalf of 8 different clients currently in federal courts around the country. So in closing, I just want to say that the need for this religious liberty clinic at Stanford is acute when we find ourselves drawn into litigation on all of these fronts that I've just elaborated on, defending the rights of religious individuals and organizations. I firmly believe that the Stanford Clinic will train the next generation of lawyers doing this essential work to provide religious freedom for Jews, Muslims, and Christians, and people of all faith. Thank you very much.
Thank you, Hannah. Our next and final speaker is Jim Sonne, the clinic director. particular interest in legal education and the advancement of religious liberty through student-led legal representation.
Thank you, Judge. Thank you, fellow panelists, and all of you for joining us today. A special thank you to our friends from the Becket Fund. It's great to have all of you with us. As evidenced by your presence and that of our distinguished participants in today's festivities, and in the energy and enthusiasm of our students who are here with us, we think we're up to something special in founding this project, this new religious liberty clinic at Stanford. We also, therefore, think the future of religious liberty is bright, or at least not so gray. What I thought I'd do with my brief time today is take a slightly different tack and describe our clinic and explain why we think that religious liberty provides a fantastic opportunity to teach students how to be first-rate lawyers in service to those in need. That is really the purpose of clinical legal education, and religious liberty offers, we think, a fantastic prism for doing that. The clinic represents a unique marriage of technique and substance. As the newest member of the law school's distinguished Mills Legal Clinic, it joins 10 other first-rate programs that teach professional skills, how to be a lawyer, through student-led representation. The students handle the cases themselves under our supervision in live disputes with real clients. Like the other 10 clinics, students enroll full-time during their term. In other words, the clinic is all that the students do for a period of roughly 12 weeks, which is a fantastic opportunity for them to practice law under our supervision, of course, in real time, and to get a sense of what it is to be a lawyer. We think it provides the opportunity, of course, to learn by doing through our supervision, and also to do so with ample time that they might not get in the fast-paced world of litigation, to reflect and to learn so that they're not only ready to practice law on day one, but also have an advanced sense of what it means to be a professional, to be a lawyer in service to others. Any honest assessment of our legal culture and the world of legal services today, I think, shows that the need for clinical education is particularly acute. As for substance, we believe religious liberty offers a dynamic and unique way to teach professional skills. Not only does the work involve many of the profound and complex and intellectually interesting questions that we've been discussing on this panel, but the hands-on experience enables our students to learn in a deeply human way. Most lawsuits involve broken human relationships, or at least misunderstandings between or among people. And religious liberty cases, as I think you've seen from this discussion today, are certainly no exception. Our clients come from a wide variety of religions, cultures, and backgrounds. And their legal problems invariably involve matters that lie at the heart of who they are as human beings. Their opponents naturally have a different take, as might the judge, at least initially. That's where we come in. This misunderstanding is particularly important for minority religions or underrepresented faiths, and that's where a particular need is and where we try to focus our efforts. But what an awesome challenge for our students, and one that we think will pay dividends in whatever line of work they choose. Representing clients who look at the conflict that they're facing, or the problem that they're facing in these deeply human terms, is a particular challenge to being a counselor in the fullest sense of the word. And so we think that this is a great way for them to learn and to serve the community. We also think it's a unique way to contribute to the community's understanding of the universal nature of religious liberty, which I think is another thing we've been emphasizing today on the panel. In this process, we hope the clinic will serve as a source of unity and help lower the temperature in some disputes that are all too often, I think, seen as disputes over religion. A lot of times you see headlines about religious liberty cases, and they instantly jump to the controversy over the religious practice involved. And yet the principle that we are addressing is the freedom, the religious liberty, not necessarily what one then chooses to pursue with that liberty in following one's conscience. In preparing for this event, we collected short statements of support from folks around the country and around the world expressing their support for our clinic. And one in particular struck me as I was trying to think about how to convey this universality principle. And it comes not from an American, in fact, but an Australian, George Pell, who's the Cardinal Archbishop of Sydney, Australia. And he wrote, quote, "None of us can avoid confronting questions about the value of life and the best way to live. Whether the answers we give to them are religious or not, having the freedom to answer them and to live our lives in accord with our answers is fundamental to a good society. I wish the Stanford Religious Liberty Clinic every success as it joins the effort to deepen understanding of the nature of religious freedom and its importance for every civilized society." Close quote. As for our cases, our docket reflects this combination of universality and diversity. This winter alone, we're working with Jews, Christians, Muslims, Native Americans on a variety of matters. For example, we are representing a prisoner seeking permission from his prison for a circumcision. That permission was denied. I think that goes to what Professor McConnell was talking about, perhaps about the administrative indifference. A land use case involving a local mosque and some of the challenges similar to the Murfreesboro case that Hannah was discussing. A prisoner seeking to engage in a sacred pipe ritual, which I think this is a Native American case, and I think that emphasizes the sort of foreign nature of some of these cases and the need for students to translate, to tell the story so that we can understand the universal interests that are at stake. A Sabbatarian observance employment case where employees were fired for observing their Sabbath. And a land use case for a church facing zoning issues over its efforts to feed the homeless. And saving the best for last, of course, are our students. We have 10 students this year who come from a wide variety of backgrounds and experience, although they share brilliance and enthusiasm in common. They're an excited and enthusiastic group whose experience in the clinic will hopefully make them not only better lawyers, but even better people. And in the end, we believe that through this new clinic, our law school will be enhanced in its effort to train students to be first-rate professionals, not only with the finest professional skills, but also a deeper understanding of what it means to be a servant leader as a lawyer in today's world. So I want to thank you again all for being here. Look forward to your questions and to getting to know all of you more at the reception. Judge?
Thank you very much, Jim.
Thank you.
Well, taking off on something that Professor McConnell said to start off, which was the difference in the division between our historical Protestant Catholic division and our present religious, non-religious division on the issues of religious liberty. I'd like to ask the question, as our society has become increasingly secularized, it appears to be difficult to express the importance of religious liberty to people who are not religious. What do you say to the skeptic or non-believer about why religious liberty is important in 21st century America? And I'll start with Professor McConnell, and then anybody else could like to chip in.
I think that most people form their deep views not on the basis of abstractions, but on the basis of experience with other people. And I think one way in which this can be done, I'm actually struck listening to myself and the others on the panel by the fact that I think Meir and I particularly have the same view that the stories of real human beings matter more than theory, right? And I think that that's really at the heart of much of this, is when you learn about real people and what they value and what they undergo, that is the sort of thing that changes hearts much more than abstraction.
Anybody else want to?
Sure. I think particularly when you're dealing with religious practices that may seem foreign. Even in our class so far, you can read about religious practices on a piece of paper, and given whatever your particular background and experience. Some of them may seem strange or odd, or maybe not that important, but then when you talk to the client and you work through the real situation, they were willing to lose their job over this, or they lost an important benefit in school or what have you. It I think lends a depth to it, and you then can show to the wider community how vitally important this is to them personally. They don't the clients don't necessarily look at this as some big intellectual, societal challenge. They look at it as this is my job or my child's school or what have you. And I think Professor McConnell is exactly right that communicating that helps.
Meir?
Yeah, I would agree with everything that both my co-panelists have said. I would just add to one other point, which is that one of the interesting things, while there is a certain religious secular divide, which is unfortunate, and as Professor McConnell said, will be the source of a lot of the religious liberty litigation that will take place. One of the coming at it from the perspective of what some others mentioned before, given the tensions that used to exist among denominations in America, one of the most remarkable things that has emerged now is very different faiths who in America have found that they have certain things profoundly in common, even as they don't do away with their profound and important disagreements about religion. And that's actually quite extraordinary. Professor McConnell mentioned John Jay and the Catholics. There was, if you read descriptions of the original Constitutional Congress, Continental Congress, when they got together in 1774, it was suggested that they all open with a prayer together, and John Jay said that they couldn't possibly pray together because they were so profoundly divided between Anabaptists and Methodists and Episcopalians. I mean, those were the religious divides that made it impossible to pray together. When I read that story, I always think about, I took some courses in philosophy of religion at Yale Divinity School, and on our student orientation day, we were sitting in a circle, and somebody there was from one of the Dakotas. He said, I really feel like I'm sticking out here being a Presbyterian among so many Episcopalians. Meanwhile, the guy with the yarmulke, right, was thinking, yeah, I hate when that happens. That's the worst. But the truth is, and then when we began to talk about our interest in philosophy of religion and how much we've learned from philosophers of religion who address matters of faith, there was a profound commonality that was found. So the flip side of that is actually, and it is a very profound issue on both sides that will continue to affect the religious liberty debates. But there's also a wonderful part of the story, I think, which we can add to that as well, which is some of the profound commonalities found among all these different faiths that might not have existed 50, 100 years ago.
Anna?
Yeah, I'll just touch on something that Jim mentioned. Sometimes some of these religious practices are, particularly of minority faiths, are not very popular, sometimes misunderstood. I remember the Becket Fund represented a Santeria priest who wanted to sacrifice certain small animals in his home as part of his ritual for ordaining new priests in his religion. And we took him on not to necessarily defend that particular religious practice, but to defend the principle of being free to worship in your own home. And you can bet that his neighbors were not pleased with the animal sacrifice that he wanted to perform in his own home. But we took that case up to the Fifth Circuit, and a unanimous panel of the Fifth Circuit agreed with us that the city's attempts to limit his ability to sacrifice these animals for certain ordinances in his home was a violation of the Texas Religious Freedom Restoration Act. So, as Jim said, many of these minority faith religious practices in particular may be very unpopular, but as we are in an increasingly diverse society where there are a lot of different minority views that are clamoring for recognition, I think what we need to explain to perhaps those who don't understand the need for religious freedom is that religious expression should be included in that diversity, and it should not be left out, that it needs to be one of the voices that is heard in this increasingly diverse society that we find ourselves in.
Yeah. I guess I'll just chime in here, because being a member of a faith that is often viewed as different, and how do we sort of explain or get a party who perhaps doesn't understand the faith or has no faith at all to feel empathy and perhaps even a commonality with our perspective. I think, when this issue in France, which continues with regard to the wearing of what they call conspicuous articles of faith in public schools cropped up, one of the arguments we've made that I found resonated with a lot of folks were, look, the state of France is saying we're going to regulate your religious dress in a public school. And a part of our argument back that resonated, obviously that rules still exist, but with people who perhaps had no faith was, look, my turban is an expression of my beliefs, just like your shirt that's red is an expression of your feeling that I should wear a red shirt today, or your shirt that says the United States shouldn't be in Iraq is an expression of your innermost feelings. But at the end of the day, it's a form of expression. And to the extent that the state or society can accommodate my expression of my faith, it needs to have an actual reason beyond just your expression makes me feel uncomfortable. That society itself must actually be burdened in a way that's substantial by the expression of my faith. Otherwise, if the state can burden my expression without a substantial reason, it can burden your expression as well. So that's sort of the argument we've made with folks of no faith or little faith or aren't used to our faith.
Well, here's a spin on the question I just asked, and which has been discussed by all the members of the panel. Given the increasing diversity in religious beliefs and practices in our society and the difficulty of defining what we mean by religion in certain contexts, why shouldn't we move to a system of general conscience protection and abandon what to some might appear to be outdated appeals to traditional forms such as religion?
Well, I think being a former Justice Thomas clerk, looking at the text and history is really important here. And when you look at the Constitution, religion is special. The First Amendment protects free exercise, and it protects from the establishment of religion. And so there is a textual and a historical reason for why religion in our American society is special and is given special protection. There was, as Professor McConnell, Judge McConnell has written in some of his articles, there was language proposed during the drafting that would have protected conscience more generally, but that was rejected in favor of the current language that protects free exercise and from the establishment. So I think the reason that religion is special is a historical and a textual one, that it's there. And there's also this sense that religious conscience is special not just because it demands certain rights, but also because it has certain duties, that people in their religious conscience, they have duties to their creator, they have duties to a supreme being, someone outside of themselves. And so religion is special not just because of the rights that it demands, but because of the duties that it requires.
Well, Hannah's certainly right on the issue of text and history, but there are those who think that this is still sort of philosophically wrong. There's a recent book by a University of Chicago law professor named Brian Leiter that makes this case, and it's not the first. Isaac Kramnik, a famous, very highly regarded historian, wrote a book a few years before that called The Godless Constitution, in which he said that religion should have no more and no less protection than General Motors. So there are those who argue this philosophically. I think I think that there are reasons why the framers were wise to differentiate. Now, first of all, in many contexts, I do favor extending protections to conscience more broadly. Very frequently, I think that that's the best solution to particular conflicts between a public policy and an individual commitment. But as a constitutional principle, sometimes when you open the door too broadly, it forces a weakening of the strength. That it's that if our position is really that everyone has the same right to do whatever they think is right, that is such a broad proposition that necessarily the content of the protection is going to have to be watered down, because as John Locke wrote, it can't be that everyone is a legislator unto themselves, right? So, and also we have two provisions of the First Amendment. There is the free exercise provision, and there's also an establishment provision, and they work together wonderfully well, and a broad conscience interpretation of the establishment principle simply doesn't work. Take, for example, many people are quite conscientiously have very strong conscientious beliefs with respect to, say, environmentalism. And they may feel really strongly about that, and hats off to them. But if environmentalism is treated as the same, in the same way constitutionally with religion, we can't have an environmental protection agency. Right? We can't have laws which are based upon the principles of environmentalism. It is the balance really between establishment and free exercise that requires that as a constitutional matter we distinguish between the two. And so I think that it simply wouldn't work to have an establishment clause and a free exercise clause for conscience in general.
Well, I think we have a few minutes left, and I'd like to invite members of the audience to approach the microphones and ask your question. And please identify yourself and identify any group with which you're associated, and then ask your question of either a panel member or of the panel as a whole, and somebody will catch on.
Hi, my name is George Barth. I'm from the music department. A question about lines drawn where a religion, let's say, would, instead of having animal sacrifice, it had human sacrifice. In other words, religion can encompass that. Okay, that's probably enough for this one.
You want to take that one?
We're not going to do human sacrifice cases in the clinic. That's correct.
Well, I mean, the supposition of your question is obviously there are limits, and there have to be limits, and in the highest legal standard that is applied, a compelling governmental interest would protect the sacrifice of human beings. So I think, obviously we have to recognize that there are some limits.
And one way you can tell the difference between a genuinely compelling interest and something else is whether it's applied across the board. And so human sacrifice, killing people, is in fact forbidden across the board. Killing animals is not forbidden across the board. We kill animals in slaughterhouses for food, we kill them for leather, we kill them for pest control. At the Supreme Court argument that Doug argued, if I about the animal sacrifice in Santorians, Justice Stevens asked whether in Hialeah it was legal to boil a lobster, right? And you know, it turns out that we can kill animals for all kinds of purposes. Virtually the only thing you can't kill an animal for in this town in Florida is because you think that your God requires it as a propitiatory act, and so I think that the gulf between these is very different. And you might also ask, if you're thinking about this contraceptive mandate case, you know, why is it that pre-existing health care plans are perfectly free not to include free, no deductible contraceptives within their plan? It's because there was a political promise made that if you like your health care plan, it doesn't have to change. And that means that for many millions of Americans, we're not enforcing, there's no contraceptive mandate across the board, which may make, at least makes me think that requiring people with a conscientious objection to do this, when we don't require people across the board to do it, suggests a certain focus on the conscientious objectors. Or the pharmacist case that Hannah mentioned earlier in Washington State. Pharmacists are free not to stock abortifacient drugs for all kinds of reasons, right? But not conscientious reasons. And that, I think, really, look at what the government does, not what it says, right? And when it allows something in many other contexts, but does not allow it in the context of a religious conscientious objection, that's where I think that's the typical pattern for unfairness.
Okay.
I'm Catherine Balin. I'm a 3L here.
Step a little bit closer to the microphone, would you?
Yes. Sorry. My name is Catherine, and I'm a 3L here. And given that at this particular moment, religious freedom is often held up as a justification for policies that target the gay population or women, or justifying practices like bullying gay kids or foisting religious symbols and practice on non-believers and members of other faith, denying women access to health care. I could go on. Practices and policies that are really very controversial and very partisan in today's environment. I wanted to ask Professor Sonne how you intend to make the clinic a source of unity and to lower the temperature around these debates, particularly given the close association with the Becket Fund, which is very involved in these issues in a very political way and has a very clear stance on many of them.
Well, I think it's getting back to my general point about focusing on the religious liberty aspect of it as opposed to the particular practice. Now, you're right that the practices then involved can be controversial, and I think what's important for us to do is, in lowering the temperatures, to be selective in the cases that we take on. We are not a litigation group that has a particular goal in mind other than to train students. And I think by selecting our cases in a way that's sensitive to the controversy, while not shying away from it, but understanding that the main goal is to teach our students, I think trying to balance that in a prudential way is what I plan to do.
Can I add something here? Just based on my experience with Becket in particular, I think it really, what I've noticed, and I don't think it'll be any different with regard to the clinic, is something that Professor McConnell articulated so well with regard to watching what the government does, not what it says. I think the strand of cases that Becket in particular has fought so hard on, and which our organization, which is a minority organization that takes issues that are positions that are often deemed unusual, the strand has always been, if the government is going to allow a practice for secular reasons, but doesn't allow it because the practice happens to be also religious, well, that's a problem for liberty. And I'll give you an example. We have a case we fought with Becket now we fought for 5 years, and it involved the issue of whether a Sikh can carry a kirpan, which is a small ceremonial sword, into a federal building. Now, based on all the rhetoric you hear, you would think that's a case that Becket would never take. But in that case, look, there's a federal practice of allowing all sorts of dangerous objects into a federal building. They even allow, there's an exemption in the federal statute that allows hunters to bring in guns for hunting purposes into a federal building. That's our law. But again, it goes back to what Professor McConnell said. Watch what the government does, not what it says. And so the argument being, if you're going to allow these practices that are dangerous for secular reasons, why not for religious reasons? And I think that's a strain that I'm very proud of Becket for always sort of defending. And I think it's a common liberty piece that most people can agree on.
We have 4 minutes left. One last question, and then we'll be adjourned. Go ahead.
Alan Reinach from the Church State Council. First, I want to thank Amar Singh and the Sikh Coalition for sponsoring the most important religious liberty bill of our yet early 21st century, the Workplace Religious Freedom Act here in California. But in thinking about many of your comments, I wonder if the devaluing of conscience, Professor McConnell, you suggested that the secular-religious divide is really the, one of the key issues. 2 observations that I hear a lot in terms of the devaluing of conscience. One, from colleagues inside the Beltway, that we have only 2 religious liberty problems in America. The left wants the state to control the church, and the right wants the church to control the state. And perhaps a corollary being that the common view outside the Beltway of religious freedom is that it means freedom to believe as I do. So I wonder if you could maybe respond to these perceptions of the devaluing of conscience. Do you see it as a greater threat from the secular or from the religious?
Anybody want to tackle that one?
I mean, I would just say that what you say makes me all the more persuaded that the religious liberty needs to be articulated by some people who are not whose agenda is neither the left nor the right, because, I mean, if what you say is true, we are in desperate need of people to say that neither of those things should happen. The government shouldn't be running the church, and the church shouldn't be running the government either, right? And so we need a voice for that.
I think that's exactly right. Just speak about it theologically for a moment. The great 20th century Talmudist by Joseph Soloveichik, my great uncle, in his essay on Jewish-Christian relations, described how faiths, he was speaking about America, but faiths find themselves always in a situation as Abraham described himself in the Bible to those surrounding him. He said, I am a ger v'toshav, I am a stranger and a neighbor among you. Meaning that on the one hand, believing uniquely in a covenantal calling that you have sets you apart from others. It sets one faith apart from another faith, and it sets a person of faith apart from someone who's secular. But Abraham is adding there that I am also your neighbor, and that's in experiencing someone genuinely, not just politically, but actually as a neighbor, that you really come to see things and to see the other person's needs, and only then the other person's rights. It's one thing to speak about rights, and it's very important to speak about rights, but it's in engaging each other and experiencing each other that we think about the duties that we actually have to one another. I highly recommend, there's a lovely book which was written by a Catholic Bible professor in Scranton by the name of Maria Johnson. She moved to Scranton and ended up living on, I was about to say the Hasidic neighborhood. There's not really a Hasidic neighborhood in Scranton, but the Hasidic block in Scranton, let's just say that. And she wrote about her experience. And this is someone who lived lives that were totally different than hers. And she wrote a book, again, never reading this theology piece from Rabbi Soloveichik. She wrote a small book about her experiences called Strangers and Neighbors. And whether you're a person of faith or not a person of faith. These issues, as Professor McConnell said, are when we experience people as both strangers and neighbors. Strangers in the sense that we understand that they have unique beliefs that set them apart. But it's as a neighbor, when you experience them as a neighbor, genuinely as a neighbor, that you experience both what makes them unique and also what you have in common.
One last word in answer to your dichotomy between the left and the right. As a person who lived in Spain under Franco, I can assure you that the government thought it was running the church, and the church thought it was running the government, and thank heavens they were both wrong. All right, thank you very much, ladies and gentlemen. It's 6 o'clock, and we're adjourned.